My name is Justin Pearson, and I have one of the greatest jobs in the world. I wake up every day, and I go sue the government. It is awesome. It's a lot of fun. I highly recommend it. I work for a group called the Institute for Justice, and we are the nation's largest libertarian public interest law firm. And what that means is we don't sue anyone for money, and we don't sue people other than the government. What we do is we provide free legal service to people whose rights have been violated, and we help them to sue the government to get judges to throw out unconstitutional laws. The Institute for Justice is a national organization. We have 7 offices. Our headquarters is up in the D.C. area in Arlington, Virginia. We also have the IJ Entrepreneurship Clinic at the University of Chicago Law School. And we have 5 state chapters. There's the Florida chapter, where I'm the executive director. And then we have chapters in Washington State, Arizona, Texas, and Minnesota. And IJ has had quite a bit of success over the years. If you include times when the government has changed the law legislatively after we filed a lawsuit, we've won about 70% of our cases. We've also been lead counsel in 5 U.S. Supreme Court cases, and we won 4 of those. In fact, even the one that we lost, the infamous eminent domain case, Kelo versus New London, created such a backlash that IJ was able to go around to 46 states and change those laws, including right here in Florida, so that what happened to Suzette Kelo's little pink house would not be able to happen here. And one of the reasons why IJ has been so successful over the years is because we focus on 4 key areas, and we've really become experts in those areas. And those areas are property rights, economic liberty, school choice, and free speech. And of course, I'm here today to talk to you about economic liberty, and specifically, I'm here to talk about occupational licensing. And if there's one thing that I would really like you all to understand when you leave here today, is that occupational licensing laws usually have nothing to do with health and safety. And I know that's counterintuitive. I know a lot of times people are resistant to the idea of getting rid of occupational licensing because they think it'll make things more dangerous, or they think these laws are there to serve some sort of public good and to create a safer environment. And unfortunately, in the vast majority of cases, nothing could be further from the truth. What we have found is what normally happens is that large entrenched businesses have realized that the costs imposed by occupational licensing laws are something that they can bear rather easily, but will keep new businesses from entering the market. These are called barriers to competition. And basically, they will crush small businesses before they have a chance to grow and become competitive with the large entrenched businesses. And because these occupational licenses have nothing to do with health and safety, it leads to all sorts of ridiculous results. Like, for example, here in Florida, it is much more difficult to become an interior designer than it is to become an emergency medical technician. It's not even close. It's so far apart. And it's not that EMTs aren't receiving enough training. They are. They do a great job. It's that the interior design lobby is ridiculously powerful. And so they created this enormous barrier to competition. Florida is one of only 3 states in the country that has an interior design lobby. In those other 47 states, there is not some outbreak of interior design catastrophes where someone trips over a misplaced pillow. It doesn't happen. But here in Florida, not only is there a license, but it is one of the most difficult licenses to get in the entire state. And it's because of this perverse, unholy alliance between big business and big government. And unfortunately, it's the little guy, it's the entrepreneur, it's a small business owner that's caught in the middle. And one of the great things about working for a large organization like IJ is it has a fantastic media team. And so I'm going to show a few short videos today. And one of my favorite videos is a video that IJ put together, kind of talking about these ridiculous laws that come about because they have no relationship to health and safety. And so I'm going to go ahead and play that right now.
Just about everyone knows that government at every level is requiring more and more Americans to get a government-issued license before they can earn an honest living. In the 1950s, well, only about 1 in 20 Americans needed the government's blessing to do their job. Today, that number is more than 1 in 3, and government puts all kinds of requirements on would-be entrepreneurs, making it harder for these entrepreneurs to start and grow small businesses. Entrepreneurs like Chuck here. This is Chuck. Oh, Chuck hates his job, but Chuck has an idea.
I'm going to fix computers in my garage and sell them for low prices.
Chuck.
My business will create new jobs for my community.
Chuck, old boy.
And give more young people access to computers. And then once my business really gets going, I can expand into a commercial space and...
You live in Milwaukee.
So?
Actually, in Milwaukee, starting a business in your home means you can't work in your garage, can't have any employees, can't have any signs, and can't take deliveries.
What?
Unless you come up with the money for a commercial lease right away, you won't be starting your business at all.
Well, if Milwaukee won't have me, I am going to start my business somewhere else.
That's the spirit.
What Los Angeles needs is a good used bookstore.
Actually, believe it or not, Los Angeles treats used bookshops like they were strip clubs or gun shops. You'll need a permit from the police to operate. You'll have to be fingerprinted. Anyone who sells you books may need to be fingerprinted too. For every book you buy, you'll have to stamp it with an individualized number that corresponds to a bill of sale that identifies the book and who it came from. The police get to inspect those bills of sale, and hold on, you'll also have to hold books for at least 30 days before you sell them, just in case the police have any questions.
But the First Amendment to the Constitution protects my...
The First Amendment? Well, how quaint. And hey, you're not planning on selling that copy of the Constitution to anyone, are you, Chuck?
Oh, for Pete's sake.
Balloon advertising? Well, that's an idea that's on the rise. Maybe you're onto something here, Chuck. But remember, Chuck, entrepreneurs aren't the only ones who have ideas. Bureaucrats have them too.
Here in Houston, you're only allowed to use balloons to sell cars, or if you have a message that doesn't sell anything at all.
That's ridiculous.
You're right. All balloons now banned in Houston.
Maybe Houston just ain't your kind of place, Chuck. How about D.C.? Oh, want to be an interior designer, huh? Not too bad. Not too bad at all. But in Washington, D.C., you'll need a license before you can tell people where to put those paintings, pillars, and planters.
But that doesn't make any sense.
Actually, that makes a ton of sense. And dollars, too. You see, existing interior designers lobbied the city to make all new interior designers, but none of the current ones, take a test and pay a bunch of money to go into the interior design business. It's a win-win for the industry and the government. Interior designers get to keep out the competition, and government gets to make money. Don't go ruining a good thing by trying to lower prices for consumers now. Now you're talking, Chuck. Miami. Nice and sunny down there. Valencia oranges and lots of tourists, too. You want to be a street vendor, huh? Well, you just need to get a little old permission slip from the city government. Ready, Chuck? Let's go. Here's all you'll need.
An occupational license from the city of Miami. An occupational license from Miami-Dade County. A license from the Florida Department of Business and Professional Regulation if you want to sell prepared food. Or, if you want to sell prepackaged food, a license from the Florida Department of Agriculture. Or if you want to sell gum, another license from the city of Miami. A city of Miami tax certificate. A state of Florida tax certificate. A certification from the Florida Department of Revenue that all your taxes have been paid. A copy of the current Florida Department of Motor Vehicles registration for your cart. A license plate for your cart. A cart certification form signed by 3 different bureaucrats from 3 different departments. And $500,000 in insurance coverage for any bodily injury or property damage caused by your vending.
Got all your paperwork together, Chuck?
Yes.
Great! Now you're entitled to enter the street vendor lottery. If you're lucky enough to win, you'll be allowed to start your business. And the winner is... Oh! Not you. Tough luck, Chuck. This is still Chuck. He still hates his job. Any ideas left, guy?
I'm just going to sell the leftover stuff from my computer business and go back to my old job.
Actually...
What?
If you want to close a business in Milwaukee, you'll need a government-issued license for that, too. And you'll have to give the government an itemized inventory every day of everything you're selling. Sorry, guy, that's just the cost of doing business. Or of, going out of business.
Oh, I just give up.
Excellent. Now, if you'll excuse me, I've got to go fix this unemployment problem.
Want to help people like Chuck? Visit www.ij.org to learn more and support IJ's work protecting economic liberty.
The last thing that should happen is to have the government get involved and keep small business owners from growing their businesses or starting their business to begin with. And it hurts everyone at all different stages. It hurts the customers who have to pay more and who also have less choices, less variety when they go to buy something. It hurts everyone who wants to go get a job because there are less jobs being created. It hurts the small business owners who simply want to work for themselves and lose that option. And all because politicians and certain entrenched interests have gotten together and created these barriers to competition. And unfortunately, I've seen them firsthand. I love small business owners. My parents are small business owners. Successful. They've overcome the burdens, but they've built a successful small business. I went to law school to represent small business owners, and I started my own business, a law firm, in order to do that. And it was because of what I saw representing small business owners with my own law firm over the course of 7 years that I finally got so fed up that I did something really crazy. I started working for free. I started doing pro bono work on behalf of small business owners because a lot of my clients couldn't afford to pay me to file some big constitutional challenge. All they could afford is for me to kind of help them deal with the problem as best they could so they could move on with their lives. And so I started doing activism, a lot of it with food truck owners and other small business owners. And that's really what caused me to cross paths with IJ, which eventually led them to offer me the position to run their Florida office. And frankly, it was just too good of an opportunity to turn up. I now get to file the types of cases that I always wanted to file on behalf of these small business owners. And you know, the things we see are really ridiculous. I mean, those are just a few examples. But it's actually scary when you think about it. I mean, at its essence, government is force. I know George Washington had the famous quote, you know, government is not reason, it is not eloquent, it is force. And those words are just as true now as they were when he spoke them. You know, it was only about, by the way, is anyone here from the Orlando area? Just, yeah. So you guys may not know this, but you may. About 3 years ago in Orlando, SWAT teams, full SWAT teams, raided barbershops based on the suspicion of unlicensed barbering. That's what it's come down to. And that wasn't an isolated incident. We have a client right now in Texas, you know, just a hardworking person. All she wants to do is earn an honest living. She doesn't want a handout. That's the last thing she wants. She just wants to work for herself. And she is engaged in a craft, a trade called African hair braiding. And this is a tradition that goes back centuries. It's perfectly safe. Kids are allowed to do it. It's not regulated. Adults are allowed to do it for free, and that's not regulated. But if you want to take your skills over a lifetime and do this all-natural process of braiding someone's hair, all of a sudden, now it's regulated. And she was arrested. She was arrested for the crime of braiding hair. And then she fought the law. Her name's Isis Brantley. She fought the law and basically got the law changed so that you could now become an African hair braider in Texas. And she built her expertise to a level where she wanted to teach hair braiding. Now she's in trouble again, because in Texas, if you actually want to teach hair braiding, you have to go and do it under the supervision of a licensed cosmetologist. Now, cosmetology school doesn't teach hair braiding, and she doesn't teach cosmetology. But the cosmetology board in Texas is extremely powerful. And so they've passed a rule that said if you want to teach hair braiding, you have to work for one of their members. And so let me show you a quick video on Isis and her story because I think it's very powerful.
7 cops came into my salon and they said I was under arrest and they took me to jail for braiding hair.
Isis Brantley is a professional African hair braider with decades of experience. She opened the Institute of Ancestral Braiding in Dallas and works with everyone from Grammy Award-winning artist Erykah Badu to the homeless.
A lot of these young ladies I found were homeless and jobless. I took them in, I trained them, gave them skills, and now they have become entrepreneurs.
In 1997, Isis was arrested because braiding was a crime in Texas unless you had a special license requiring years of schooling that had nothing to do with braiding. Isis fought the licensing law for years, and though she won the right to braid, Texas didn't back down completely. Instead of passing braiding laws that make sense, it simply wedged a 35-hour license for braiding into the existing barber statute. Now, Isis is fighting for the right to teach the next generation of braiders.
I've been teaching people to braid hair since 1984, and I want to be able to teach the course at the Institute of Ancestral Braiding.
But Isis can only teach the 35-hour braiding course at an existing barber school. Otherwise, she has to build her own barber school and take expensive and pointless barber classes.
The bottom line is that Texas has no problem with Isis teaching. It just has a problem with her working for herself.
To teach braiding for a living in her own school, the government says Isis must turn it into a 2,000-square-foot barber college. And she has to install things that have nothing to do with braiding, like adding 10 barber chairs and 5 wash stations she'll never use. Isis also needs useless things like short-haired mannequins and barbering textbooks. Plus, she has to go back to school for 750 hours of barber classes.
Braiders aren't barbers, and braiding instructors shouldn't be forced to build barber schools or take classes from barbers.
That's why Isis is fighting for her rights once again. She's teaming up with the Institute for Justice to file a federal lawsuit against Texas.
This lawsuit means for me economic liberty for my community. And it's important that we change the laws so that everybody else can be treated fairly.
A victory for ISIS will help braiders and entrepreneurs across Texas and beyond.
Economic liberty is especially important for Black women. This is our new civil rights movement.
So, it's messed up. And so you see these stories over and over again of people, oftentimes, unfortunately, although everyone's rights are important, it's just, I'm always struck by how often these victims are just small businesses or low-income workers, moderate-income workers. It's the middle class and the small business owners that the politicians are always talking about. Those are the ones getting harmed by these rules. And unfortunately, not too many people are sticking up for them. And it's enough to sometimes make you wonder if there even is a right to economic liberty in this country. But there is, at least there was supposed to be. When the Constitution was written, it was written by people who believed in natural rights. In fact, if you read the Declaration of Independence, it basically sounds like John Locke wrote it. He was a famous natural rights philosopher. And so whereas the Declaration of Independence laid out the philosophy for our new country, it was the Constitution that tried to implement that philosophy. And the people who wrote the Constitution weren't perfect, and the Constitution will never be a perfect document. But what they tried to do was they tried to create government to the extent that they thought it was necessary to protect the rights that already exist. They believe that you have natural rights that exist regardless of the government, and the government is inherently evil, but it is a necessary evil that should just exist on some small level in order to protect the natural rights you already have. And so they created a government that was only supposed to be one of limited and enumerated powers, that wouldn't have the ability to interfere with your natural rights. And then on top of that, when it came time for the Constitution to be ratified, many of the people who wanted to vote for it required that they add a Bill of Rights. And that was pretty confusing to some of the founders because they said, wait a second, we created this Constitution for this government of limited and enumerated powers. You don't need a redundant Bill of Rights. The government we're setting up is just something that's going to consist of small islands of regulation in a sea of liberty. You cannot list all the rights. It's impossible. You have infinite rights. But in order to get the Constitution ratified, they had to agree to come up with a Bill of Rights. And at no point did it even cross their mind that this Constitution would create a government that could interfere with economic liberty. I mean, during the debates over the Constitution, you'd hear people, or you can read even in the transcript, people say things like, well, should we list a right to put on a hat? How about waking up when we want or going to bed when you want? Because you have these infinite rights. And so the way they fixed that problem was the Ninth Amendment, which says, listen, we're going to list some of these rights, but don't let that mean that we don't have other rights. You have rights even if they weren't listed here. And then, of course, you can't talk about economic liberty without perhaps my favorite amendment, which is the 14th Amendment, because that one really directly arose out of economic liberty concerns. As hopefully many of you know, the 13th Amendment abolished slavery, but in the aftermath of the 13th Amendment, people started to realize that just abolishing slavery wasn't enough, that you don't have freedom unless you have the freedom to control your own destiny. And just removing the label of slave isn't enough. And so you would see all these issues in the South, in the former Confederate states, where former slaves were basically forced to go back and work for their former slave owners because they did not have economic liberty, because the entrenched interests had created different laws and different occupational licenses that were directly and intentionally designed to keep the former slaves from being able to earn an honest living for themselves. And so what the 14th Amendment did, as hopefully some of you know, is it applied the rights in the Constitution to the states so that it wouldn't just apply to the federal government anymore. And it made clear that those rights included economic liberty. And for many years, the United States Supreme Court really did a good job of protecting economic liberty. But obviously they don't anymore. And so it makes you wonder, well, what happened? And I think it goes back to a discussion that the founders had early on. Early on, Thomas Jefferson warned us that it was the nature of government to expand. It was the nature of things for liberty to give way. And so the framers had to think, well, wait, we need some type of government that helps us protect our natural rights, but we need to keep it constrained. We need to keep it as small as possible. And I think James Madison said it best when he explained how to do that. And of course, you've all heard of the checks and balances. But what James Madison really thought would stop the government from growing would be the judicial branch. And James Madison said that federal courts would be, and I love this quote, an impenetrable bulwark against every assumption of power in the legislative or executive. And so you had this government on one hand that was supposed to be small but just inherently wants to always grow. And on the other hand, you had these federal courts that were supposed to use the Constitution to keep the government from growing. Because the framers understood that the purpose of this new republic that they were creating was not democracy. Democracy is great, but it has flaws. The end result was supposed to be individual liberty. And the framers recognized that when your rights are being violated, the fact that the majority of people may have voted for that does not make it any better. In fact, it makes it worse, which is why federal courts and federal judges aren't elected. It's because we need them to stand up for those people's rights who are being violated, even when it's unpopular to do so. In fact, that's the most important time to do so. But unfortunately, judges are not impenetrable bulwarks. They're people. They make mistakes. You know, sometimes the government slips one by the goalie and government grows. And other times, they just don't do their job intentionally. And that's really what happened during the New Deal. I don't know, I'm just curious, for my own education, how many of you have heard of the switch in time that saved 9? Yeah, well, a few of you, it's something. So basically, up until the New Deal, there was an era of Supreme Court jurisprudence called the Lochner era. It's named after a famous or infamous, depending on your view, Supreme Court case that upheld economic liberty. And there were actually a whole series of those cases. But during the New Deal, FDR, was passing quite a bit of New Deal legislation, and some of it was getting struck down by the U.S. Supreme Court. And so FDR did a great job of really villainizing the Supreme Court in the press. The media was just ripping them to shreds. The public hated them. FDR was very popular, as you know. And so finally, FDR said, listen, if you don't start upholding my laws and saying they're unconstitutional, I'm going to pack the court. Because the Constitution doesn't say how many Supreme Court justices there would be. And so he would say, listen, my party controls Congress. If you keep ruling these laws that we pass unconstitutional, we're going to increase the number of justices, which then obviously we'll have to fill those vacancies, and we'll fill them with people who will say that our laws are constitutional, and we'll pack the court. And now, I should point out that we don't know if the court packing scheme was really the reason why the Supreme Court switched. The main justice who switched his viewpoint and started voting in favor of the new laws was a justice named Owen Roberts. And unlike most other Supreme Court justices who have their memoranda and notes, let them be published at some point so people can learn from them, Justice Owen Roberts burnt everything he had so that no one would ever find out why he changed his mind. And then when he left the bench, there was this problem where the Chief Justice said, wait a second, we have this problem. Everyone's saying that you changed your vote because you were bullied by FDR. You need to fix this. And so Justice Owen Roberts wrote a brief memo saying it wasn't because of FDR. We had already kind of decided even before he threatened us. Now, maybe that's true. Maybe it's not. I know other people suppose that what really happened was during the landslide election of 1936, Justice Owen Roberts became frustrated with just being so unpopular, and that's why he gave in. Either way, whether it was because of FDR or whether it was because of the 1936 election, either way, it was a totally illegitimate reason to change his mind, and that's why it's referred to as the Constitutional Revolution of 1937. And at that point, the floodgates were opened, and we've created this giant bureaucratic monster in the government at all levels of government. I know in the video that I showed to start, it talked about how at one point, not that long ago, shortly after the New Deal, only 1 in 20 people had to obtain a license to work. Now that number is 1 in 3. And it's because basically the US Supreme Court has stopped enforcing economic liberty. In fact, it got so bad that people thought, you shouldn't even waste your time bringing an economic liberty case. The Supreme Court recognized that there was a right to economic liberty, but you were never going to win, so why waste your time? And the reason is because in the aftermath of the 1937 Constitutional Revolution, after the Supreme Court had shredded large parts of the Constitution, they realized that there were parts of the Constitution they cared about, like free speech. And so they came up with the bifurcated standard of review, where basically rights like free speech still get reviewed under strict scrutiny, which is real judging, and other rights like economic liberty get reviewed under something called the rational basis test, which basically means fake judging where the government always wins. And so, before IJ came along, people had kind of given up on economic liberty as a constitutional right. They knew that it technically existed, but no one would ever win. And so IJ said, wait a second, we know there's this right. There has to be cases out there that are so extreme that a judge will ignore this whole idea of rubber stamping government action and will actually rule in favor of the small business owners. And so they went and found them. And just like all the other cases, the government would walk into court and argue, hey, judge, economic liberty, rational basis test, dust off the old rubber stamp, we win automatically. And oftentimes that's what happened. But IJ was able to find such outrageous cases that were happening all over the country that IJ started to win, at least some of them. And then once that happened, now when the government argues that they win automatically, IJ can say, no, sometimes we win. There's some level of judging involved here. And as soon as that happens, we have a fighting chance. Because the examples are so extreme. I mean, the victims are so sympathetic and the government bullies are so out of control. And so it's a slow and steady progress to get rid, and slow and steady fight to get rid of these occupational licensing laws. But it's what we do, and I have a lot of fun doing it. I know it's a serious subject, but we actually have a lot of fun because we just run into these absurd situations. And I think one of the best illustrations of it has to do with 3 cases that we filed on behalf of people who build caskets. It turns out that the funeral industry has a lot of power around this country. And so they've created some pretty ridiculous barriers to competition. Funeral directors are not casket manufacturers. Casket builders are not funeral directors. But in many states, funeral directors have passed laws or have been able to convince their representatives to pass laws saying that you can only sell a casket if you go and become a licensed funeral director. And now in these states, there's no law saying you have to be buried when you die. And if you want to be buried when you die, there's no law that says you have to be buried in a casket. If you want to be buried in a casket, there's no law that says what that casket needs to be made out of. And if you want to buy it from someone out of state, you can buy it from whomever you want. But if you want to buy a casket from a human being in the state where you live, they have to be a licensed funeral director. It makes no sense. And so the Institute for Justice filed a case in Tennessee, and it went up to the Sixth Circuit Court of Appeals. And just so you all know, there are basically the way the Court of Appeals work in the federal courts, the country is divided into 11 regions. And there are other courts as well, like the DC Circuit, but for all intents and purposes, there are 11 regions. And so in the Sixth Circuit, which covers Tennessee and some other states, IJ was able to convince the court to throw out this barrier to competition. And that was the first time since the New Deal that a federal appellate court had ruled in favor of an economic liberty plaintiff. But the Supreme Court didn't take the case. We won at the appellate level. The government appealed to the U.S. Supremes. The U.S. Supremes weren't interested. They're not usually interested in economic liberty, so it wasn't a big surprise. So then we filed another case. We filed a case in Oklahoma. Basically the exact same case, exact same fact pattern I just mentioned to you. Have to do with this licensing requirement that you be a licensed funeral director with all that entails, all the education costs that entails, just to sell caskets that you make. And that went up to the 10th Circuit Court of Appeals. And the 10th Circuit Court of Appeals said something pretty outlandish. They recognized that what the funeral director lobby was doing was just for their own self-interest, that it wasn't tied to any legitimate health and safety concern at all. But they still ruled in favor of the funeral board. And what they said was that basically things are so bad, things are so corrupt, the self-dealing is so widespread that they're not going to open up that can of worms, that they're not going to rule those laws unconstitutional, that basically helping out a special interest for no other reason than to benefit that special interest is enough to meet the rational basis test in federal court. And the quote, it just boggles my mind, so I want to show it to you so I don't misstate it. While baseball may be the national pastime of the citizenry, dishing out special economic benefits to certain in-state industries remains the favored pastime of state and local governments. That was a court upholding the law. That was a court saying that it was constitutional. That's how bad things have gotten. So we filed a third case. We were angry. And by the way, we appealed to the U.S. Supreme Court. There was a circuit split in that situation. That's supposed to increase the chances of the U.S. Supreme Court taking the case, but like I said, the U.S. Supremes don't care about economic liberty, so they shot it down. So we pulled out all the stops. We filed a case in Louisiana. Does anyone know who we're representing in Louisiana? Nobody? First rule of public interest law, whenever possible, represent monks. And so that's who we found in Louisiana. We found these monks. They live on a monastery in Louisiana. I'm not making this up. I'll show you the video in a second. And they have, and basically, you know, part of their mission in their monastery is they need to be self-sufficient. They have to pay for health care and all the other things that they have as human beings. And so what they do there is, you know, they take their trees and they use the wood to build these very noble, simple, basic caskets, and they sell them. And in Louisiana, it's got the same laws that I talked about before. You know, you're not required to be buried in a casket. It's not required to be made out of wood. You can buy it from whoever you want out of state. But if you want to buy it from a person in the state of Louisiana, it needed to be a licensed funeral director. The monks had no interest in becoming licensed funeral directors. They didn't want to direct funerals. They didn't want to install an embalming room onto the monastery. They just wanted to sell these basic caskets that they build in their little wood shop on their monastery to people who didn't want to get ripped off by the funeral directors. And of course, the funeral directors fought back, and they fought back hard, because one of the ways they make a lot of money is by jacking up the prices on caskets to rip off customers. So let me show you this video so you believe me that we actually did represent monks.
Well, the monks of St. Joseph Abbey feel very strongly that we have a right to an honest living through the building and the sale of our abbey caskets.
But Louisiana doesn't respect that right, so the monks have taken the Pelican State to federal court. As monks have done for centuries, the Brothers of St. Joseph Abbey in Covington, Louisiana, put food on their table through the labor of their own hands.
The monks of St. Joseph Abbey have been making caskets for over 100 years. People who ask for them want to share in that noble simplicity that our coffins express.
My husband really wanted to have a simple burial. He lived life simply, and he wanted to have just a simple wooden coffin, and so the monks were able to provide that service for us.
But it's a crime in Louisiana to sell a casket unless you're a state-licensed funeral director, and the government has launched proceedings to punish Abbot Justin Brown and Deacon Mark Coudrain.
For the sin of selling a casket, which is really just a box, the monks face crippling fines and even jail. And they've also lost an important way of supporting themselves.
We're not a wealthy monastery, and we need the income that St. Joseph Woodworks could generate for the health care and the education of our own monks.
The state is going after the monks because licensed funeral directors want the casket market to themselves. There's an unholy alliance in Louisiana between government and the powerful funeral industry lobby.
The monks have teamed up with the Institute for Justice in a major federal lawsuit to protect their right and the right of every American to earn an honest living, free from economic protectionism and other outrageous government interference.
Bureaucrats and special interests are so out of control in this country that not even monks are safe. The Brothers of St. Joseph Abbey are ready to go all the way to the Supreme Court if that's what it takes to restore economic liberty to grassroots entrepreneurs everywhere.
But that's the type of thing we see when we sue the government in its own court. We won that case at the trial court level, so the government appealed, and we went up to the Fifth Circuit Court of Appeals, and we won there too. And so then the government tried to appeal to the U.S. Supreme Court. The U.S. Supreme Court wasn't interested. So now there are 3 cases on this issue out there. 3 cases on whether it is okay for the government to pass a law for no other reason than to help a special interest. That's what decided those 3 cases, that one issue. So those wins, although they were great, they're really modest wins. It's not like we totally opened up economic liberty for everyone, but it's a step in the right direction. And so that's what we have to do. We have to just keep chipping at it, over and over again over the course of many years, and keep moving forward, trying to make things a little bit more free for everyone and get rid of these ridiculous occupational licensing requirements that don't help anyone and just jack up prices and hurt small business owners. Thank you.
talk a little bit about, you were discussing the 14th Amendment and its effect on economic liberty. How do you feel about the expansionary nature of the 14th Amendment through incorporation and substantive due process, and how that has basically been expanded now to the extent that it's used all over the place as arguments for almost anything?
Right. That's a great question. Thank you. For those of you who have not studied the 14th Amendment, basically it has three parts. You have the well, first you have the Privileges or Immunities Clause, which is actually my favorite part of the 14th Amendment, and was intentionally written to mirror the language of the Privileges and Immunities Clause, which has to talk about your rights, and that's what those words meant. Privileges and immunities meant rights in the parlance of the time. And then you have the Substantive Due Process Clause and the Equal Protection Clause. And it was really the Privileges or Immunities Clause that was designed to protect your economic liberty, but through a ridiculously erroneous decision called the Slaughterhouse Cases, that part was read right out of the Constitution because the Supreme Court felt that if they applied it, that would change the Constitution. Apparently, the Supreme Court never looked up the word amendment in the dictionary, because that's what an amendment does. But they decided that the Privileges or Immunities Clause just wasn't going to be followed. But then what happened is, after that point, you have this situation where they still recognize, it was long before the New Deal, so they still recognize that there was this right to economic liberty. And so what they would do is they would take other parts of the 14th Amendment, usually the Due Process Clause, and they would apply it to cases where really the Privileges or Immunities Clause should have been used. And that led to problems. I mean, I agree with you, it's problematic. The best thing to do would be to go back. It's not going to happen. So the Supreme Court hates to reverse itself. It hates to reverse prior generations. One reason being that the Supreme Court doesn't want its own opinions getting reversed when they all retire. Another reason is that you actually have to have some sort of predictability with the law. In order for the law to be enforceable, it needs to be predictable. And so I don't think, or I mean, I would love for it to happen, but it's unlikely that the court's just going to come out and reverse the Slaughterhouse Cases. But that would make the most sense, would be to actually go back and treat the 14th Amendment the way it was supposed to be treated. Then you'd have clear situations where the Privileges or Immunities Clause should apply, the Due Process Clause should apply, or the Equal Protection Clause should apply. Instead, what you have is the Supreme Court just using whatever they have available and kind of jerry-rigging it to fit whatever the situation may be, and it definitely leads to problems. However, I would tell you this. I am much less concerned about the Supreme Court striking down too many laws than striking down too few, regardless of what part of the Constitution they use. I mean, and part of it's just my own preferences for liberty. I think, I'm going to paraphrase Thomas Jefferson here, but I'd rather deal with the problems of too much liberty than not enough. And so that's really what the Supreme Court does, is they strike down laws. Sometimes they rewrite laws. Unfortunately, they're not supposed to, and people complain about activism, and that's a legitimate concern. But when I think of the cases that really infuriate me the most, I think of cases where the Supreme Court bit its tongue. I think of cases like Buck v. Bell, where they allowed the state forced sterilization programs to go on, where approximately 70,000 women were sterilized against their will because the Supreme Court ruled against Carrie Buck, whose only crime was that she was raped by a friend of her family. I think about cases like the Karematsu case, where Asian Americans during World War II were in prison for no other crime than where their ancestors were born. And these are cases where the Supreme Court looked at the issue and then looked the other way. That bothers me much more, and I think causes much bigger problems than cases where the Supreme Court maybe strikes down a law that they shouldn't. And I know that was a very long-winded answer. Did I even approach where you were going with that question?
No, absolutely. I was just curious, and mainly I was also going as to the effect that it's had on the idea of federalism and the 10th Amendment.
Well, I mean, that's a great point, too, because obviously that was a concern that they had with the 14th Amendment, that now, and there's actually a clause in the 14th Amendment that gives Congress the power to pass laws to implement the 14th Amendment. And so basically what you're doing is you're affecting the balance of power between the federal government and the state government. And that is a concern, even as a libertarian, that's a concern on some level, because in my view, if you are going to have power, you need it as limited and decentralized as possible. And obviously that goes against that a little bit, but it goes against that in a way to increase your individual liberty, to increase your rights, to give you extra tools to stand up for yourself against whatever level of government you're dealing with, and so that's why I'm a big fan of the 14th Amendment. Any other questions? Are you all scared now after that answer? Yes?
So for Dr. DeRosa's research in his class, the Supreme Court case that I just did research on was Cripple versus the SEC.
Okay.
I don't know if you're familiar with it.
I don't know that one.
Okay, then I don't have a question for you.
Oh, you want to tell me the gist of it?
I can give you an outline of actually the case. The Supreme Court ruled that 5 years post the commission of a financial fraud was the cutoff for the SEC to be able to go back and extract penalties from that.
Okay.
And I guess I'm curious as to whether you would side with the court's decision on saying yes, it's just 5 years, or the previous court's decision saying it was 5 years since the discovery of fraud. Especially because in your last comment you said that there needs to be a steady set of rules where you don't understand.
Right.
And since that case, there's already been 3 cases where the federal judges have thrown out in excess of $100 million penalties that should have been gotten from these fraudsters.
Wow. And now just so I'm clear, these were actually brought by the SEC, not private parties?
SEC.
That's curious. That's interesting. It's a situation that does lead to some different opposing value judgments. I mean, on the one hand, you're right. As I mentioned before, and this is true, the law needs to be predictable. You know, if people are going to follow it and it's going to be enforced. And I'm not an anarchist. I may seem like one because I'm so opposed to everything that's happening these days, but I agree with some of the things that some of the people who wrote the Constitution said, which is that you need some level of government to protect your rights. On the other hand, you know, you have this issue when you're a victim. And I did commercial litigation, primarily on behalf of small business owners, but still I did it for many years before I joined IJ. And you have this issue sometimes with people who have victimized and don't know right away. They honestly just don't find out right away. And so you have, you know, the interests of just people knowing, being able to know and move on with their lives and know that there's not some lawsuit lurking on the one hand, with the interests of a true victim on the other hand, who found out about something 5 years later for whatever reason, because it was covered up or it's just a type of problem that doesn't appear right away. As a constitutional issue, I don't know if I could answer that. It's a very interesting question. I could be okay with it going either way. And I could be upset with it going either way, you know, depending on my mood at the moment. You know, I always passionately believe in what I'm saying, but I reserve the right to change my mind. And it's a great question. I appreciate you bringing it to my attention. I'll look those cases up. I understand the dilemma. I don't know which way I would have gone if I were on the court. Yeah. I will tell you this one thing, since you brought up the SEC. You know, when I first got out of law school, I went to work for a securities litigation firm for a few years before I started my own practice. You know, law school doesn't teach you how to practice law. And so you really need to go work somewhere after law school to kind of get the proper training. And so I went there and I was an attorney in cases in state court and federal court. And we did a lot of work going up against the SEC on behalf of not big companies, just small companies, but, you know, publicly traded companies on a small scale. And it's really disturbing the way they do things. I mean, our whole justice system is disturbing in many ways. I don't know if you guys know this, but on a per capita basis, we have a higher percentage of our population in jail than any other country on the planet. And I don't think it's because our people are evil. I think we have too many laws. And so you always have to question kind of the way the justice system goes about doing things. Radley Balco has a great book out, if you're interested in that, called The Rise of the Warrior Cop, which talks about kind of how police have implemented military techniques, and it's just, the stories are incredible. But anyway, going back to what I was saying and dealing with the SEC, you know, a lot of times, whether you agree with what the police are doing, generally speaking, what they're supposed to do is they're supposed to cut deals with the small fish in order to get them to catch the big fish. The SEC does the opposite because the big fish have money. And so you'll see when the SEC settles with these giant investment banks, what will happen is you'll see that the bank pays some giant amount of money to the SEC, and then if you actually look at the fine print, someone will go to jail because someone has to go to jail. But instead of it being like the head guy, it's some like junior vice president of something or another that was just tangentially involved. Because that's what the SEC does. They cut a deal with the big fish and throw the small fish in jail because the big fish pays them money. So I'm not a fan of the SEC, but I know that was not even really related to what you asked. There you go. I'm happy, you know, as you can probably tell, I'm happy to answer any questions you have. So if there are any more.
One last one.
Sure, go ahead.
Sorry, last one, I promise. Could you talk a little bit about what you feel the constitutional ramifications are of recently overturning the standard filibuster rule, and do you see a concern now for what, in essence, is going to be court backing?
Yeah, I was disappointed when that happened. You know, I'm not a fan of either major party, but one of the things that helps me sleep at night is knowing that they're both so incompetent that they can't get a lot done. And so, you know, just think about how scary the world would be if the government were more efficient. You know, so when that rule went away, I was disappointed, and I think you're right. It's gonna lead. You know, as you pointed out, the issue that really brought it about was the whole issue of judicial appointments, and we're gonna get a whole bunch of appointments pushed through, and they're going to be on the bench for a long time. And when you're dealing with the federal court, that's a lifetime appointment. And in case I ever appear in front of those judges, I'm sure they're all well qualified. You know, I just want to say this since this is going out on YouTube. But yeah, that was a sad day for me, and I think there will be ramifications for a long time. Yeah. Thanks. Anything else? No? All right, well, listen, I have some materials there at the back you guys are welcome to pick up. Also, our website is phenomenal, ij.org. It has these videos as well as many others, as well as my email address. So if you think of a question, send me an email, give me a call. I'm happy to talk to young people like yourselves. Thanks again.